webinars, which started in July 2022. The topic for today speaks to the regulations which flow from the Domestic Violence Amendment Act 14 of 2021, which was assented to by the President on the 25th of January 2022 and is pending enactment. For those of you without the legalese, this means this law is not in operation yet. A very warm welcome to everyone that's still joining us on the platform. My name is Deline Clark. I'm a state law advisor based at the South African Law Reform Commission, and I've had the privilege of being part of the Department of Justice team, which drafted the Domestic Violence Amendment Act, and I'm a member of the Gender-Based Violence Pillar 3 Committee. And the Pillar 3 of the National Strategic Plan relates to deliverables on the gender-based violence legislation. So I will be your moderator for today. So just to ensure that we all engage and receive the best value for our time together, and I do see that you're all respectful of the protocols already, but it's important just to start off with a bit of housekeeping. With regards to time, we'll be together until 4 o'clock, and the webinar will comprise a presentation section and a section for you to engage with the presenter. Please keep your videos off and your microphones muted until we reach the discussion section, where you'll be invited to post a question or to engage with the presenter. Please do use the chat box for your questions and your comments, and please also type your name and email in the chat box if you'd like the presentation distributed to you. Mr. Dequeni of the Department of Justice is on the platform and is ready to take your details. All the presentations and material will be made available online and placed on YouTube. So as with the blurb on the airlines, we're almost ready for takeoff. I am, however, unfortunately unable to offer you any refreshments. That's the nature of the virtual engagements that we're having nowadays. So this brings us to the topic for today, the regulations to the Domestic Violence Amendment Act. And by way of introduction, regulations provide the nuts, bolts, and oil to ensure that the wheels of the various provisions in an act run smoothly. It, for example, provides for the forms needed to apply for a protection order. As you may be aware, the Domestic Violence Amendment Act did not only result in many matters requiring regulation, it also required a total overhaul of the existing regulations to ensure a clearly mapped out pathway of services. Mr. Mac Mokulubete, our presenter, has been the driving force behind the drafting of these regulations and was a key member of the team that drafted the Domestic Violence Amendment Act. It's truly an honor to introduce him to you today. Mr. Mokulubete is a graduate of the UKZN. He's obtained a BA, LLB, and an LLM degree. He's an admitted attorney of the High Court of South Africa, and he's currently employed as a state law advisor in the Chief Directorate Legislative Development in the Department of Justice and Constitutional Development. Mr. Mokulubete has meaningfully contributed to providing a legislative framework aimed at addressing the scourge of interpersonal violence that our nation is plagued with. So once again, it is an honor to introduce you to Mr. Mokulubete. Thank you, Mac. I'm going to hand over to you now, and I hope you're on the platform. Mac, are you with us? Mr. Dequeni, have you been able to assist Mac?
I'm trying to call him, but he's not on the platform as in yet, so I'm trying to call him.
I think this presents us just with an opportunity then for the people who are on the platform just to briefly introduce yourself and to say just your name and the organization that you're representing, please. We can start off, I think, in the trying to see if I could see the list of people. But if we could start off then with the first person on my list being Engelbrecht. Thank you.
Yes, good afternoon. It's Andre Engelbrecht, Office Manager, Magistrate Office in Drina.
Thank you, and a very welcome to you. If we could just go down the alphabetical list then and hand over to the next person, please.
Good afternoon, colleagues. My name is Ashika Premlal. I am a program specialist with an organization called NACOSA. We are providing GBV prevention and response services and supporting the Department of Health facilities under the USA PEPFAR grant. Thank you.
And welcome to you.
Good morning, I'm Brigadier Denise Beekers from the South African Police Service Gauteng. I'm the head of litigation in Gauteng.
Good morning, I'm Colonel Matawa Pala at SAPS Provincial Legal Services in Gauteng, Crime Ops. Thank you.
Good afternoon, everyone. My name is Mzokolo Khusi. I'm a senior state advocate working for NPA Soccer Unit, which is Sexual Offences and Community Affairs. I'm based here in KZN.
Good afternoon, colleagues. My name is Mashiano Kemapulani, Social Work Policy Developer, Department of Social Development, Provincial Office in Gauteng.
Good afternoon, I'm Pumeza Machai, Legal Services, SAPS Head Office.
Good afternoon, Lieutenant Colonel Luke, Legal Services Head Office.
Good day, I'm Colonel Grobler, also Legal Services in Gauteng, and we're from the Litigation Office, and my legal officials is also sitting in with me.
Good day, colleagues. I'm Namsam Timunye, with Bank Thuthuzela Care Center.
Good afternoon, colleagues. I'm Nomsapa Pale, Lifeline South Africa, the manager for Stop Gender Violence Helpline. Thank you.
Good afternoon, colleagues. I'm Justice Chabangu from the Department of Justice, Limpopo Regional Office.
Good morning, colleagues. It's Tutuzi Mnyandu. I'm a prosecutor in Foster's Court, Johannesburg.
Afternoon, colleagues. My name is Tracy Keen-Woodcock. I'm a state advocate and the case manager of the Thuthuzela Care Center in Evander.
Good afternoon, everyone. My name is Yoloka Zimjoli. I'm a site coordinator at Edendale Thuthuzela Care Center, KZN.
Good day, I'm Kenzi Tsimani, Director for Legal Services, Mpumalanga Department of Justice.
Good afternoon, colleagues. I'm Hazel Francis. I'm from the Department of Education, KZN.
Good afternoon, colleagues. Lieutenant Colonel Prinsloo from Legal Services, Crime Operations, Eastern Cape.
Good afternoon, colleagues. Major General Billet. I am the head of Legal Services, Eastern Cape. SAPS Legal Services, Eastern Cape.
Afternoon, everybody. I'm Lieutenant Colonel Hansen, Legal Services, Operational, Eastern Cape. Thank you.
Good afternoon. My name is Service Potgieter. I'm with the NPA. I'm a prosecutor at Hatfield Magistrates Court in Pretoria.
Good afternoon, everyone. I'm Tandiwe Boy, social worker from the Department of Social Development in Gugulethu Office, Cape Town.
Good afternoon, colleagues. My name is Constance Kandarachu. I'm the social worker at Social Development Network. Please.
Thank you for those popcorn introductions. I don't know if anyone else has not had a chance. I'll give you a second or two just in case there's one or two people who may not have had an opportunity yet to introduce themselves.
Yes, good afternoon. My name is Asya Khan. I'm the Director Legal at Justice, KZN.
Good afternoon. Good afternoon. My name is Tandim Dlalose from Department of Communications and Digital Technologies. I deal with gender and disabilities. Thank you.
Good afternoon, colleagues. I'm Taro Sironya, Senior Prosecutor at Mufasa in the Northwest.
Afternoon, colleagues. William Mata, State Advocate, NPA, Sexual Offences and Community Affairs Unit. Thank you.
Well, welcome to everyone. It really is a formidable team of people that we have on the platform this afternoon. I see we have a hand from Mr. or Ms. Jamison, if you'd like to come in. It looks like it might have been by error. Mr. Makulubete is just trying to connect. As you know, it's Murphy's Law. When you need to connect, you can't. So if we just give him a few seconds, if you don't mind, while he's actually transferring to another computer to try and see if he can have access. With your permission, we're now at just shy of 2:15. We'll give until 20 past if that's in order with you. If you could just show me a thumbs up from your side. Or yeah, that's basically the only opportunity we have, but please do show me a thumbs up if you're okay with us just waiting until 20 past for him. Mr. or Ms. Mududuzi, are you giving a thumbs up or are you showing that you would like to say something at this point?
Yeah, sorry, I'm giving you a thumbs up on that one.
Thank you, I do appreciate it. For anyone who's just joined the platform, we're having a few technical glitches. Mr. Makulubete has just changed computers and he will try and join us by 2:20. Thank you for your understanding in this matter. Lwando, could I ask you, have you admitted Mac to the platform yet?
No, ma'am. He's also not in the lobby.
Ms. Maroke, do you have your hand up? Okay, I see it's gone down again. Mr. Dequeni, would you then perhaps just guide us on the way forward, please? Because I'm not sure the connectivity, and I know that people have given of their time to be on time at 2, and they've been very accommodating here. So I wonder if you could just guide us on this, please.
see my camera? Okay, let me.
Hi, Mac, I can hear you. We were just about to try and postpone, but I can hear you, which is great.
Okay.
So if you're ready
Okay,
to
hi,
take
Chair.
over.
Please don't. Please don't postpone. Are you able to hear me?
I'm able to hear you very well, Mac. Thank you. And thank you for all the effort you're going to get connected.
My sincere apologies to everyone. Yeah, it has been a nightmare. Nothing like this has ever happened before. And I do sincerely apologize for that. And I'm going to go just rushing back to my office so that I can be settled in and so that I can be able to switch on my camera. And but in any event, I'm sure, moderator, you have done the introductions and everything.
Yes, thank you, Mac, and we're really looking forward to hearing from you.
Okay.
Thank you, and I hope you can connect now and have a bit more of a peaceful introduction into this. Thank you so much. I hand over to you.
Okay, thank you very much. Can you see my video? I have my video on now.
Yes, we can see you.
Yes. Just to start with, I'm sure you have introduced me, but just for completion's sake, my name is Makubela, and my surname is Mukudubete. I'm a state law advisor here at the Department of Justice and Constitutional Development. I'm one of the team members who worked on the Domestic Violence Amendment Act, which necessitated the development of the regulations that I would like to discuss at this webinar. With all that, I'm going to try to share the presentation that I will use to do this briefing. And I'm trying to put the presentation up now, if I may be given a few moments to do that. My system doesn't allow me to put up the presentation now. I wonder if the Secretariat are able to do that for me, Madam Moderator, if at all possible.
I will try from my side, Mac.
Yes, please, if you can be able to do that, I'll appreciate that. And I will just try to guide you in terms of the pages or the slides. If we can go back to slide 1 or slide 2, actually it will start with the heading background. It will have one background.
Are you able to see that?
Yes, I'm able to see that. Thank you. I just want to.
Could we perhaps get an indication from anyone else on the platform if they're able to see?
It was visible earlier, but then it disappeared on my side.
Yeah, it has disappeared on my side as well.
Yes, it disappeared.
Okay, no, here it is back on. Yeah, I wonder if Madam Moderator can put it on presentation or slide mode so that it can be much bigger than it is now. Okay. In any event, I will continue so that we can try to catch up with the time that I have wasted due to technical glitches. The slide that I will want to be put up on the screen now will be the one that talks to the background, in terms of which I intend to indicate that the president of the country has, as we know, signed into law the Domestic Violence Amendment Act 2021, and this was done on the 25th of January this year. And amongst the provisions that are contained in the Amendment Act will be amendment to Section 19, which provides for the regulations in terms of which the minister, and this will be the Minister of Justice and Correctional Services, is empowered to make regulations regarding any form, the regulations regarding financial assistance to a complainant or respondent, to a witness. If we can scroll to the next slide. And the minister is also empowered to grant or to make regulations for the granting of legal aid at state expense and in appropriate instances. And this must be done in consultation with Legal Aid South Africa. And we all know perhaps that Legal Aid South Africa is the statutory body that has been established to provide legal assistance and representation to the indigent throughout the country. Even though the Legal Aid South Africa has been providing for legal aid and legal representation to the indigent in relation to domestic violence matters, it was seen as necessary that it should be incorporated in the Act itself so that it can be there in black and white, even though legal aid is already providing that. And furthermore, the minister is empowered to make regulations regarding any matter that requires to be prescribed under the Act, and any other matter that the minister deems necessary or expedient. This is what we call a catch-all provision that enables the minister, even if a provision is not specifically stipulated in the Act itself, this provision empowers the minister to make a provision or to make regulation in relation to a provision to an extent that the minister deems it necessary or expedient in order to make sure that the Act operates optimally. Now, the Amendment Act has brought so many provisions that requires us as the department to make regulations, and this is not a new invention. We already have the regulations under the Domestic Violence Act that are in existence, and they have been promulgated as long ago as 1999. And these 99 regulations are going to be repealed by these new regulations. Now, if I may go through to the regulations, Regulation 1 provides for the definitions. We have come up with a to facilitate, which Madam Moderator, I don't know if I'm still on the platform. I seem to be disconnected. Am I still in?
Mac, you are. You just faded away a little bit at that point where you were talking just after the Regulation 1. Thank you.
Yes. Yeah, thank you. Thank you, Madam Moderator. Yeah. These definitions are intended to, to facilitate the interpretation of the regulations and the Act. And you will see when you go through the regulations, there are a number of those, but for the purpose of this presentation, I have isolated two of the most important ones. One being electronically, the definition of electronically. Through the advent of the Amendment Act, you will see that we are coming up with a system that is going to be used for the application for protection orders, which can now be done electronically instead of the manual system that currently exists. And as a result, we need to have a provision that, or a definition of electronically that relates to the service by any electronic medium, such as fax, email, SMS, MMS, and other social media. So it's going to be much easier because the life that we live now has to some extent been occupied by the use of electronic means, and we are incorporating these for the purposes of being able to apply for a domestic violence protection order. The second one is an online portal. We are developing a system that is going to be used where the applicant or a complainant who wants to apply for a domestic violence protection order can be able to access the web and be able to apply for a domestic violence protection order using that very portal. Regulations 2 and 3 are not new provisions, and they have been existing, or they are currently existing in terms of the current 1999 regulations. However, we have inserted a few more. Chair, Madam Moderator,
Sorry.
there's someone, I think it's
Could I
Deborah.
ask you to turn off your microphones, please, if you've just joined the meeting? Thank you.
Thank you. And then I will go to the next slide, which will take us to the provision relating to the functionary. You will all recall that in terms of section 2A, 2 capital A2 of the Act, a functionary is required to take certain necessary steps. In this instance, we are talking about a functionary who believes or suspects that an act of domestic violence has occurred, and the Act requires that a manner be provided as to how that functionary is going to report such acts of domestic violence to a social worker or the police. The functionary will mean it has been defined in the Act, and it includes persons like medical professionals, social workers, teachers, and etc., etc. Those are functionaries who are required to report acts of domestic violence. Now, in terms of this regulation 4, we have designed a form that is going to be used by the functionary to be able to submit that report to the police or the social worker. And the manner of submitting that report will be by hand or electronically. Furthermore, in terms of section 2 capital B2 of the Act, it is a flip side of section 2 capital A2. But in this instance, it's not talking about a functionary, but it talks to an adult person who knows or believes or suspects that an act of domestic violence has been committed against a child, a person with a disability, or an older person. So this adult person is obliged to submit a report.
Sorry, Mr. Makula, but Madam, would you please turn off your your mic, please? Excuse me, ma'am, would you please turn off your mic? Thank you. Mr. Dequani, could
Deborah
I ask you
Machaba.
to help with that, please? Thanks.
Thank you. I will proceed because I was saying that in this instant, any adult person is obliged to report acts of domestic violence against a child or a person with a disability or an older person to a social worker or the police. And we have been required in terms of this section to design the form in a manner of a submission of this report by an adult person. So that the form that will going to be used is Form 3, and it can be submitted by hand or electronically by that adult person to the police or a social worker. On to the next slide. The next slide will talk to Regulation 6, which is a regulation that is talking to the list, a list that a peace officer is required to provide to a complainant or a person acting on behalf of the complainant. So the Act requires us to design this list, and then this list contains details of accessible shelters and public health establishment. So now a peace officer is required to hand out this list. However, this list will not contain the physical addresses of the accessible shelters, because in that way the respondent will be able to locate easily where the complainant is sheltered. So we have decided to exclude the physical addresses of the shelters. However, the addresses of the health establishment will be contained so that they can be able to see where to go when there is a need for going to a health establishment. Now, this list can be given by a peace officer to the complainant or the person who is acting on behalf of the complainant by hand, or it can be done electronically. However, a complainant can also be directed to a website where this list can be accessed. In addition, we have designed a Form 5, which is a notice that the peace officer must hand out to the complainant. Now, this notice will contain information that must be given by the peace officer to the complainant relating to the rights of the complainant in terms of the Act. The content of the notice must be communicated to the complainant by the peace officer in question, and the complainant must be alerted to the available remedies in terms of the Act, and they are also required to give further assistance as contemplated in Section 18B of the Act. This relates to the referral of the complainant for medical assistance or a referral to the police or social worker, to a shelter or an alternative accommodation, or even to a court to apply for a protection order. So what we are saying here is that the peace officer will give this notice and even go to an extent of explaining the content of the notice, and the list that contains the addresses of the shelters and the healthcare establishment must be available on the website of the department. So even if maybe in some instances the peace officer will not be in possession of this list or the notice, they will still be available on the website of the Department of Justice. Regulation 7 is not a new provision. It actually is a replacement or a replica of the existing Regulation 4. And What we have done in terms of this, we have included certain provisions which are necessary for the improvement of this regulation. Relating to the submission of the application form, which is now Form 6. We normally know it as Form 2 currently, but it has now become Form 6. This is an application that is going to be used when an application is being brought for the protection order in terms of the Act. And this application can be submitted to the clerk of the court, either physically in person or electronically, or through the online portal that I have talked to earlier on, in terms of which the applicant can be able to access the portal and be able to apply for a protection order on that platform. Now, the other insertion was that the application will require the applicant to state the court. There will be a list of the courts on the system. It will be in a form of a drop down where the complainant will be able to tick the court that has jurisdiction to deal with the matter that the complainant is bringing before that court. So there will be a drop down. However, in the physical or the hard copy applications, then the application will require that the court having jurisdiction be stated specifically in the application there. The new provision that we have come up with as required by the Act is to invent a form, which is Form 7. Is a form that we have designed to be used by a victim or the complainant when they give consent to the bringing of the application on their behalf. Remember, the amendment that we have brought on the table was that even though that provision was still there, an application could still be brought on behalf of the complainant instead of the complainant bringing the application themselves. So now we have designed the form so that there can be a uniform approach throughout the country in terms of the bringing of the application on behalf of the victim of domestic violence. So in this regard, we have designed this Form 7 that is going to be used when the victim decides to give consent to someone else to bring the application on their behalf. Now, Regulation 9, what we have done is because now, in terms of the Act, there are certain documents and information that must be captured by the clerk of the court, specifically in the repository. So now, Regulation 9 is a regulations that we have designed to list each and every document that needs to be captured in the repository. So now, if you, instead of clerk of the court going to the Act to see whether a particular document needs to be captured in the repository, they will just be able to go to Regulation 9 because it will list each and every document without fail that needs to be captured in the repository. Regulation 10 is a provision which is it's a new invention as contained in the Act. I think it's Section 4, capital A of the Act. It is a new invention in terms of which a victim or the complainant who is applying or has applied for a protection order can at the same time or after that application bring an application for a safety monitoring notice. We have designed a form that is going to be used to apply for that safety monitoring notice, as well as a form of a court order when the court grants this safety monitoring notice. So Form 9 will will be a form of application for this notice, and Form 10 will be the court order when the court grants the safety monitoring notice. And the clerk of the court will be obliged, and not later than 2 hours after the court has dealt with the application, and notify the complainant of its outcome, and this must be done telephonically or electronically. So what's going to happen is this. Once the complainant decides to apply for the safety monitoring notice, the court is going to consider that application, and if the court decides to grant that, the clerk of the court will be required to pick up the phone and call the victim or the complainant to say that your application for safety monitoring notice has been granted or has not been granted. So this is to avoid the practical experiences that occurs in our courts, where the complainants, after they have applied for protection orders, they are required to go frequently to court to check the outcome of the application. So what we have come up in terms of the Amendment Act was to ensure that the clerk of the court will update the complainant of progress in relation to application for a protection order, rather than the complainant going to check the status of the application to court, which is an inconvenience. And because now in some instances, the complainant will have to ask some time off work, so as just to go and then establish what is the progress in relation to their application. Now, once the court has issued the Form 10, which is the court order authorizing the domestic violence safety monitoring notice, the clerk of the court will be obliged to serve the issued notice to the station commander who has jurisdiction in respect of service in the area. The relevant station commander will be required to assign a member of the police. So what's going to happen is that the clerk of the court will immediately, or after the court has issued the safety monitoring notice, the clerk of the court will have to submit it to the station commander either by hand or electronically. And once the station commander has received that, yes, he or she has 24 hours. No, I beg your pardon. The station commander is required to assign a member of the police, and that assigned member of the police will have 24 hours to serve the court order on the respondent, and that member can do that either by hand or electronically, and must thereafter contact the complainant as well to update the complainant of progress in relation to the service of the notice. The complainant will be notified either telephonically or electronically whether or not the notice has been served. If it is served, the complainant must notify. If it's not served, then the complainant still must be notified. Now, once the member of the police has taken necessary steps to effect the service of the safety monitoring notice, they are going to have to report to the court. We have designed a form that is going to be used to report to the court as to the activities of that assigned member of the police, and this will be Form 11, in terms of which the member is going to give certain information to the court, particularly in relation to when and how that member contacted the complainant after that member received the notice from the station commander. When did the member communicate with the complainant? And they are going to report whether the complainant appeared to have been hurt or threatened when that member went and to see and communicate with the complainant. So those details must be set out in that form, and it's going to be submitted to the court. And if the complainant was hurt, And if it's necessary for referral, then that member is entitled to give the complainant an advice as to whether to go for medical assistance or to a shelter, depending on the circumstances of that particular complainant, including the opening of a criminal complaint. This is what the member of of SAPS must do, and then the member is required to report in that very same Form 11 each and every step and activity that the member undertaken in relation to that particular case. Regulation 11 deals with the issuing of the interim protection order. And if we skip to the next slide, this is not a new provision. We have inserted additional provision that provides for the manner of service of the documents on the respondent. Likewise, the clerk of the court must immediately notify the complainant if the interim protection order has been issued by the court, and the clerk of the court can notify the complainant telephonically or electronically. So this is just a measure of making sure that the complainant is kept up to speed as soon as possible, or even immediately, without delaying the knowledge of the complainant in relation to their cases. Regulation 12 deals with the notice to show cause and is not a new provision. We have inserted additional provisions that relates mostly to the manner of service of documents on the respondent. And we are making a provision that if the court does not issue the interim protection order, the clerk of the court must notify the complainant telephonically or electronically that firstly, the court has not issued the interim protection order. Secondly, that the court has issued a notice to show cause. That is, if the court issues the interim protection order, that interim protection order is going to be served with the date on which the appearance should take place in court. But if the court does not issue the interim protection order, then it's going to issue this notice to show cause, being a notice that will reflect a date on which the respondent will be required to make an attendance in court. And thirdly, the clerk of the court will notify the complainant of the date set for the hearing of the application. Regulation 13 is the provision that deals with the manner of service. The certified copies of the interim protection order and the original warrant of arrest must be served on the complainant. And this will be to enable the complainant to have in their possession the original warrant of arrest. They will need that the original warrant where there's been a breach of the interim protection order by the respondent. So this will enable the complainant to have in their possession the original warrant of arrest. Regulation 14 provides for a subpoena of any person to appear as a witness. This is Form 14, and it is different from Form 15, because Form 15 is the form that is going to be used when a person is subpoenaed to provide a book, a document, or an object, such as a USB stick, a video, or a disc, or audio clip. So if a person is subpoenaed to attend, just to attend and give evidence, then only Form 14 will be used, will be issued and served on that witness. However, required, then Form 15 will be issued and served on the respondent, or on the witness, I beg your pardon. so that they can be able to know what they are required to bring in terms of an object such as a USB stick, or whether they are required to attend to give evidence. Now, once the warrant, the subpoena has been issued, then it must be served on the person who is required to make an attendance or to bring an object. And this service can be done by hand or electronically. And that person must be given a copy of that subpoena, and it must be served 10 days before the date of hearing, so that they have at least reasonably enough time to make preparations for the attendances at court. Regulation 13 provides for the manner of service. If we can go back to slide 12, it provides for the manner of service, and it enables the well, Chair, Madam Moderator, I think we have dealt with this. My apologies. Can we go to slide 13 then? Which is the provision that deals with the Regulation 15, which prescribes a form which will be Form 16 to be used by the court when the court requires a certain particulars from the electronic communication service providers. So what is happening here is that in terms of the Act, we have came up with a certain provisions that relates to the electronic service providers, because this is where the domestic violence or act of domestic violence takes place at the cyberspace. It has been done electronically by WhatsApp or whatever, fax or and so forth and so forth. So now we have come up with this provision that will require the court to give an order that will require the electronic communication service provider to give certain particulars that will enable the court to make a determination in relation to a matter before that court. At the same time, we have this Regulation 20, which prescribes Form 23. The court is now, in terms of the Amendment Act, empowered to order the electronic communication service provider to remove or disable access to a certain offensive electronic communication. So once this the order has been given, that is in the form of Form 23, the clerk of the court will be required to serve it immediately on the electronic communication service provider, and then this will be done electronically, but it must be done not later than 1 hour after the order is made. Obviously, because of the urgency of the matter, the court will require that access be disabled for that electronic communication, or the communication itself be removed immediately. So that must be done as a matter of urgency. Now, there is this form that has been designed, that is Form 24, where the electronic communication service provider wants to set aside or amend the court order. They can be able to use this form. There will be instances where this electronic communication service provider is unable to give particulars because, for instance, that provider does not is not provider of the facilities that have been used by the respondent to maybe post the electronic communication. They are able to say, I'm not able to give this information because it does not apply to me, and then they can be able to apply to set aside the order that has been made by the court. So this application to set aside or amend must be done within 14 days after service of the order. and must be served on the clerk of the court by hand or electronically. The electronic communication service provider will, however, be required to show good cause as to why the order should be set aside or amended. Regulation 22 makes provision for the refund of the amounts that or the amounts that would have been paid to the electronic communication service provider. For the giving of that information to the court by the electronic communication service provider, there is a tariff that they're going to use to charge for providing the court with that service. Right. So now, once that has been done, the court is able to make an order as to who's going to pay that, and in some instances can order the state to pay the electronic communication service provider. However, at the end of the case, the court has to make a determination as to who will have to refund the amount that will have been paid by the state to the electronic communication service provider. Regulation 23 deals with the new amendment that has been brought by the Criminal and Related Matters Amendment Act, which inserted paragraph B in section 6012 of the Criminal Procedure Act. That section provides that if the court is satisfied that the interest of justice permits the release of an accused on bail in respect of an offense that was allegedly committed by the accused against any person in a domestic relationship with the accused, and a protection order has not been issued against the accused, the court must, after holding an inquiry, issue a protection order. So this relates to criminal matters, obviously. And if the court is inclined, that is the criminal court this time around, is inclined to issue the accused person with bail, the court is entitled to hold an inquiry to make a determination as to whether a protection order has to be issued against the accused person. And if the court is satisfied that there are grounds that are necessary and sufficient to issue the protection order, the court will be able to do that. And this will be in terms of this new section 6012B. Regulation 12 provides for the extension or the discharge of an interim protection order. There will be instances where the parties do not appear in court. For instance, if the applicant does not appear, or the complainant, but the respondent does appear in court, then the court will have to decide whether to discharge the interim protection order or to give an extension so as to enable the complainant to make an appearance in the next occasion. So then there will be a form that is going to be used to notify the parties of the extension or the discharge of the protection order, and this will be a Form 31 that is going to be used for such purposes. Regulation 25 is not a new provision. We have made some necessary insertions there regarding the capturing of the issued warrant of arrest on the Integrated Case Management System, the ICMS, also relating to the uploading and the capturing of the warrant of arrest on the Integrated Electronic Repository. I would like to pause here to just make a recap as to the purpose of this Integrated Electronic Repository. This repository was established in terms of Section 6(a) of the Amendment Act, in terms of which all necessary information and the documents are going to be captured in this Integrated Electronic Repository. This is to ensure that these documents can be accessed at any time or anywhere whenever they are needed. You remember that in practice, we know it's a common occurrence that documents, for instance, the protection order itself, it gets missing, it gets misplaced, it gets destroyed, and so forth and so forth. So now, with this integrated electronic repository, those necessary documents will be able to be accessed electronically at any time and at anywhere. So now, as I've mentioned in terms of Regulation 9, there are those specific documents that are going to be captured in the integrated electronic repository so that they can be accessed at any time and from anywhere. Regulation 27 is not a new provision. It talks to the affidavit, which will now be in the form of Form 35. We have inserted some additional provisions there, in terms of which the affidavit, that is Form 35, must state specifically that the respondent has contravened a prohibition, condition, and obligation or an order contained in the protection order. The specific prohibition that has been contravened by the respondent, and you remember I did mention that in the electronic system, we are able to do all of these things that we have been able to do manually or physically. So on this system, there will be a drop down of all of these specific incidents, which will just be ticked. For instance, a specific prohibition, then in the affidavit, then there will be a tick where it is necessary to tick that condition or prohibition on the system. However, in the affidavit itself, the physical one, then all of these must be specified that the respondent has breached the following conditions or the prohibitions. Those must be stated specifically in the affidavit. And the extent, if we can go to the next slide, the affidavit will require the explanation as to the extent how did the respondent contravene an order or the provision that has been made by the court. In terms of Regulation 29, once the court has issued a final protection order, then the clerk of the court will be required to inform the station commander of the nearest police station. This will normally be the police station that is servicing that area. So the clerk of the court will have to notify the station commander within 24 hours that there has been a final protection order that has been issued against the respondent. And obviously this will happen in instances where the respondent is the owner of a firearm as contemplated in the Firearms Control Act. So now this notification by the clerk of the court to the station commander will enable that station commander to act in terms of the provisions of the Firearms Control Act, in terms of the determination of whether the respondent is fit to possess a firearm. So there's a form that is going to be used to notify the station commander. This is Form 37. We have designed this form so that each and every court can be able to notify the station commander uniformly, so that no one notify in different manners. So this form will enable everyone to use the same form to notify the station commander. Regulation 32 is not a new provision. It's a general provision that deals with the service of documents in terms of the Domestic Violence Act. We have inserted certain new information or provisions relating to service. In the first instance, we have onto the next slide, we have established a form of the return of service, which is going to be used by the clerk of the court, the member of the South African Police, or the sheriff. If there's a return of non-service, that is in instances where the respondent cannot be found for the purposes of a service, then that return must state the reason of the inability to serve the respondent, as well as the attempts that have been made to attempt or to effect a successful service of the document on the respondent. The return of service must be filed with the clerk of the court as soon as possible by the sheriff or the police, and this must be done not later than 24 hours after service or after an attempt to effect service has been done. We also have a new provision relating to the filing of a document by hand or by hand delivery to the clerk of the court, or by sending that document to an electronic mail address or the fax number of the clerk of the court, or as I've mentioned once before, that can be uploaded on the online portal, which will have been established for these purposes. The person who submits or sends the documents electronically to any other person will be required to obtain a delivery report. For instance, if it was sent by fax, then a fax transmission report. If it was sent by email, then an email as a transmission report will be required. So that information will be required to be kept by that person who has accepted the document as proof that there has been a service or an attempt to serve a document. Now, there is this provision that has been introduced by the Act that requires that if the respondent is unlocatable or has moved to another area that is served by another police station, for instance, or by another sheriff, then the sheriff must file a return of non-service, stating that very fact, to say that the respondent no longer is within this area, or whatever reason, as an indication of the reason of non-service, and then the clerk of the court must be able to act in relation to that information as contained in the return of non-service, where the clerk of the court can notify, for instance, the complainant that there is this non-service, and the complainant or any person who requires a service to be effected can be able to apply for a substituted service. Substituted service is a service that will be authorized by the court. So that person will have to apply to the court for the authorization of any other alternative manner of service, so as to ensure that the respondent is served. Regulation 33 deals with appeals and reviews. This was inserted because of the realization in practice that in some courts, the notices relating to appeals and reviews pertaining to civil matters, they are just mixed together with the documents relating to domestic violence. So what we have done, we have made a provision that will require the clerk of the court to maintain a register, that there will be a separate register for the appeals and the reviews relating to domestic violence matters. Those will then be separated from the civil matters so that at least those can be easily identifiable in terms of which one is which. The Regulation 34 is a provision that talks to the costs where the either the complainant or the respondent or both do not have the means to pay for the costs that are required for a service of any document in relation to a domestic violence protection order. The court can order the state to pay that cost, those costs, only if the court has established that the respondent or the complainant or both of them are not able to pay for those costs. This will relate mostly to those services that will have been effected by the sheriff in instances where service by the sheriff will have been necessary, as will have been determined by the court itself. Regulation 35, you'll remember I did mention that Section 19 of the Act has been amended to require the minister to make regulations relating to the provision of legal aid for the indigent. So what we have done in terms of Regulation 35 was to make sure that the regulations established under the Legal Aid South Africa Act are applicable in relation to domestic violence matters. So those regulations are going to be used for the determination of the granting of legal aid to the indigent. On to the next, and I presume the last slide. This will be the conclusion. As assented to the Domestic Violence Amendment Act, and this happened on the 25th of January this year. This Amendment Act coming into operation on the 30th of November this year. This brings me to the conclusion of my presentation, and on to a thank you note just for allowing me to give this presentation. And with all that, I thank you very much, and once again do apologize for the glitches that I have experienced. And I'm giving back to Advocate Delin Clark. Thank you.
Mr. Makulabesi, thank you so much. And Ms. Mandu, could I please ask you to turn off your video? I think that brings us to the question and answer time. And
it's a Kempton Park, so it means if I'm not going like.
Excuse me, we have some. Sorry. Hello. Mr. Queenie, could you help us mute the person, please? And Ms. Mandu, would you please turn off your video? It interferes with the bandwidth. Thank you so much. I'm going to hand over to the participants just to pose any questions that you might have. Please do either put it into your chat box or raise your hand, and we'll then take the questions. I'll take the first 3 questions and then we'll take it from there. Thank you. I see there is a question in the chat box, and unfortunately, due to the dual presentation, I couldn't see the questions that they were going on. I see Ms. Khan has asked, is electronically referring to the means to apply for a protection order or service of documents? Please clarify. I'll hand that over to you, Mr. Mokolobeti, just to speak to that.
Thank you. Electronically will mean, if you can check the definition section, will refer to the manner of a service. We have outlined there the various manner of service in terms of which a document can be served by fax or by email. So electronically will refer to the service. There will be a portal that is going to be established for the platform where the formal application for a protection order will be available. So what is going to happen is that once you access that platform, there will be a page that is going to open that will require to be filled in terms of the relevant particulars like the code, etc., and then the specific orders that the complainant requires the court to order. They're going to be ticked on that platform, and then with the click, then they can be submitted to the court. So in short, the platform will be for the application of the protection order, and then there will be other documents and activities that will be able to be conducted on that platform. And however, electronically, as defined, we are talking to the manner of service by electronic means. Thank you.
Thank you, and I hope that did speak to or respond to your question. I see that there's a hand by Mr. Nyongwane. Would you like to unmute yourself and pose your question, please?
Okay, thank you so much, Chair. I think a couple of things that actually are quite good. Number one is that it's a good set of regulations, and we keep on raising this very constantly over and over again in all the issues in terms of it as well. That one issue I need to raise, that the practicality of implementing that to all police stations, that's going to become a big crisis, because currently now, in terms of training methodology, that we've called how many times the readiness of the SAPS in terms of looking into implementation part, that's one problem which may just have a challenge now with it as well. The second one is that to become practically in the situation as well, maybe we have a session then with all station commanders in the country on a virtual platform where we take them through the set of regulations and the DV Act at the same time, especially a section there where the court will give an order of court and basically say that the fire must be retrieved in terms of the basis then of domestic violence as well, Act being created on this basis. That how then will we sort to that implementation is taking place? That's one level I want to ask on a question. And second, that the complexity of the regulations, how will we see to it that it filtered then to the many of the regulation, should it not be implemented, what will the recourse be for them in order that they can hold the SAPS accountable on the basis, especially when it comes to the service point, because domestic violence has become a serious issue in South Africa, and it become a big issue on the red flag SAPS is taking on the matter, and that becomes an issue of lack of accountability. Thanks, Chair.
Thank you, sir. Over to you, Mr. Mokolobeti.
Thank you, Madam Moderator, and thank you to the question by Gregory. What you are raising is a very important issue, and indeed, we will all be looking out with open eyes to see that the regulations are complied with by everyone who's required to comply therewith. This some of these, mostly this electronic stuff, is a new thing, and we do not. We hope that everything can go well from the beginning, but we do not expect things to go smoothly from the very beginning. We will experience glitches. That's what happens with every piece of legislation that is new. There will always be those glitches that will be encountered, and in the long run, the glitches will ultimately be smoothed out, be resolved, and easy manners of dealing with those be established, and so forth and so forth. So yeah, indeed, the implementation part of a new legislation is always a difficulty, and we are only hopeful that the relevant stakeholders will be able to comply with all the new requirements in terms of the regulations. And the police will obviously, they will have to come on board, because what we have done here, we are not coming up with a new thing that that is a surprise. The regulations that we have come up with here are actually triggered by the Amendment Act that has been assented to on the 25th of January this year. So what we are doing in terms of the regulation is just to beef up what the Act requires us to do. So everyone should have would have foreseen that something is coming their way. The Act was saying there must be a manner of service, and the regulations must provide for that. We are coming up with the provisions that require certain things to be done in a certain way. Certain documents must be served in a certain way, particularly electronically. So the police should have been aware as early as when the Act was assented to, that there will be certain manners of service that will be expected of us as the police. The station commander will know that they will be served with a domestic violence safety monitoring notice, and the regulations are going to specify the manner of serving that document. One of those will be electronically, because basically we are coming with the electronic way of doing things here. So it will be expected from the police side and everyone else, including the complainant themselves. Everyone is included in this, that we will have expected that manner of service electronically was coming our way, and this should not come as a surprise. However, in short, Gregory, all I'm saying is that it won't be smooth sailing for everything to happen from the beginning smoothly. We expect glitches, but we hope that those glitches will not take place for a long time, because the people who are going to be disadvantaged will be our complainants, who are going to be disadvantaged as a result of the inability to do things that are supposed to be done, especially on an electronic platform. Thank you.
Thank you for that. And if I could just add, I hear the hesitation, and I think for those of us who've been around for long enough, you may think back to 97, 98, when we were transitioning across from the Prevention of Family Violence Act to the Domestic Violence Act, and how we thought we were going to face so many challenges in implementation there, and yet the police stepped up so well. And I think what we're trying to do in terms of this legislation is to have a comprehensive pathway of services so the burden doesn't fully fall on the police. And having said that, I think too that if you do have a request for a presentation for the station commanders, please do, send a mail to Mr. De Queni and we could arrange for something like that. Alternatively, as I said, and you may have missed it at the beginning of the webinar, all of the recordings that we've been flighting since July of 2022 are available on YouTube and can be used as a training resource as you may wish to use. Mr. or Miss Rusi, I saw that there was a hand. I don't know if I missed you there. And if you do want to come in, please do.
Yes, good afternoon, everyone. My question is only one question. Looking at Section 6, the Criminal Law Amendment Act, Section 60, I think it's...
Sorry?
Yeah.
Hello?
Yes, I'm saying looking at the Criminal Law Amendment Act, in considering bail, which says that a presiding officer must look at point 1, 2, 3 and see if it is an interest of justice to release the accused person. Is that then make it the cases of domestic related matters to fall within Schedule 5 for bail? Did you get my question?
Yeah, no, I did get the question. Thank you for that, Zoko. No, on the contrary, then we are not escalating the acts of domestic violence to that schedule. What is intended here is to say that for whatever offense that the accused person will be facing, and there's an application for bail, and the court is inclined to grant that application or to grant bail, then the court is required. Those will be separate issues. The court will be required to issue a protection order. In terms of, instead of following the domestic violence route, the court will be following this section 6012B to say that I want to release the accused person on bail. However, in light of these factors, I see it in the best interest that a protection order be issued when the accused person is released on bail. So it doesn't escalate acts of domestic violence and then include them within Schedule 5. No, that is not the case.
I mean, 5.
And I do not foresee, Mzokolo, I do not see how it can be interpreted that way. And even the section is clear itself that the court must hold an inquiry if it contemplates giving the accused bail. The court will hold an inquiry to determine if it is necessary and in the interest of justice to issue a protection order. Instead of the complainant having to go to the domestic violence court, the criminal court can do that, and everything is going to be transferred to the domestic violence court to deal with the processing of the domestic violence in the normal course. Thank you.
Mr. Rusi, does that answer your question or do you have a follow-up? Is there anyone else that would like to pose a question or have something for clarity? I see we have Mr. or Ms. Potgieter. Please do go ahead.
Good afternoon, and thank you, Ms. Moderator. I just want to make a follow-up question regarding the bail proceedings and issuing or the inquiry by the magistrate into the protection order to be issued. So should I just want to know, my question is actually the time frame for the, say the magistrate court or the bail, the court of first instance of bail. What will be the time span for the matter to be transferred, or should the court grant or after the inquiry say or recommend that protection order should be issued? What would be the date, the time of postponement then? Because the problem I have here is, or just I need clarification, if I may. Should they transfer the matter to the domestic violence court, and in the interim, when the accused is released on bail, commit an offence then, but there's no order yet out? Wouldn't that pose a problem then for him then to commit a crime whilst he's awaiting the hearing in the domestic court? Thank you.
Well, thank you for the question. The details relating to what needs to happen are contained in the Regulation 23. What's going to happen is that once the court issues, the court will issue, there's a form that we have designed for that, and the court is going to use that form to issue a domestic violence protection order. And you remember, the accused person will be in court at that time. The order will be made because, remember, this is at the time that the accused is facing the magistrate with an application for bail, right? Now, the court is going to issue the protection order immediately if it is satisfied in terms of that. And obviously then the respondent will know of the contents of the order. However, there will still be, in as far as I'm concerned in this case, there will still be a service so that there's a record for the purposes of the domestic violence court. There will be a service of the protection of the interim protection order, and the clerk of the criminal court will immediately, remember, if you can check the regulations, will require that once the court, that is the criminal court, issues the protection order, the accused will know immediately of the contents or the orders that are contained in that protection order, that the respondent will be prohibited from contravening and will be released on bail. And then the clerk of the criminal court will transfer the case. This is the domestic violence case, that is the protection order, and the record of those proceedings will be transferred to the domestic violence court, where the file will be opened in the criminal and in the domestic violence court. And at the same time, there will be a service of the protection order, even though the accused will have been notified of the contents of the protection order there and then. So if the whilst released on bail, the accused breaches one of the orders contained in the protection order, then they will be liable. They will have to face the music for the breach of the protection order, because they will have been aware of the orders as they will have been made in his presence or her presence in court, though before the criminal court. And if they breach that, they will have breached the court order as if they would have breached the order issued by the domestic violence court. So the process will still be the same, except that the protection order will have been issued by a different court this time around. Hence, then the court or the clerk of the court of the criminal court will have to transfer immediately the file to the domestic violence court. I hope this answers your question. Thank you.
Yes, if I could just add to that, and perhaps just to clarify, when the court does decide to issue bail, it will be the issuing of a final protection order and not an interim order, so that there won't be any period of time in between, because the court, on what it has heard, will then make that judgment call at that point in time. I hope that answers your question, Mr. Potgieter. Mr. Nyongane, I think I see your name. Sorry, would you like to come in again?
Yes, thank you, Advocate. I just want to also thank Mr. Mkhulubete. That answers my question, and thank you for you also clarifying it, because I also had the question, then will it be a final or interim? And I just think it is an excellent innovation, and also to protect the complainant for the courts to now grant this protection order, because the problem was always the time space, or whilst the accused was on bail, to commit this. And the problem we are facing is during that time space for the complainant to then first go and obtain a protection order now. And now the court has put in place direct protection on the first appearance, whilst we are dealing with bail proceedings. And I think it's a excellent innovation, and that answers my questions. Thank you very much. I appreciate it. Thank you.
Thank you for that. It makes all the late hours worth it. If you have a look at section 6012, you'll see confirmation of that, of the CPA. Thank you. Can I hand over again to Mr. Nyongwane?
Okay, thank you, Advocate. Advocate, a couple of things that we just now, I think Potgieter has brought my mind to something else as well, that we got a type of scenario that women open up an interim order of abuse against husband when intend divorcing him. That's one level. Then the second thing is that then a husband, because of his malicious way of doing things, doesn't want to sign any return of service from the police, take his car, run away, comes next, they start swearing at the woman and go to police station, go and lie, and then from there that he's also going to do an application and for that. But end of the day that he still keep on doing what he needs to do, but every time he's been protected because he also got a story about something, end of the day that, which actually becomes that a lot of verbal abuse happening, but it cannot really be proved in that way. That's one of the issues that, which we pick it up a lot in a lot of cases. The second scenario I want to create it here as well, that we got a picture of what you call it, habitual domestic violence applicants. Those
I don't know it's network or what. I can't hear anything. It's been 15 minutes.
Okay, we got an habitual.
So if I could just, sorry, could I just interrupt you there, Mr. Katlego? I think it might be a network problem on your part. I'm not sure. Sorry, Mr. Nwani, could I ask you for perhaps one question at a time, so we could just hand over to Mr. Mkhulubete, and just to get anyone else on the platform who'd like to have an opportunity then too, please. Thank you.
Okay, you can then answer the one. The first one I've actually just posed that one scenario there, because it's a continuous scenario in various cases happening currently now in the province, where men actually then do what you call that, just do the repeat process to protect themselves, so that end of the day that women mustn't go ahead and with a restraining order or with the application of interim order as well. How can you really avoid such situation in terms of the regulations?
Mr. Mkhulubete, I hand over to you.
Yes, thank you, Advocate. Yeah, look, the fact of the matter is that if the court has issued the interim protection order, or even the final protection order for that matter, and then the contents thereof must be brought to the attention of the respondent. obviously then by way of serving same on the respondent. Well, it's common occurrences that the respondent will try to evade a service. I don't see how it can be regulated in the regulations as to how it can be done or what can be done in terms of ensuring a service of a proper service on the respondent. However, if that is why we have that that invention or innovation in terms of the Amendment Act, where the if the normal manner of services then the court can be asked to authorize an alternative manner of service. For instance, if they dodge that and disappears, the respondent gets in the car and disappears without a proper service has having been effected. That's when the police are going to notify the clerk of the court so that the alternative manner of service can be effected. Remember, the alternative manner of service can even be by electronic medium. You know, obviously, the complainant is in a domestic relationship with the respondent. The complainant may know other platforms, like they will have their fax number, they will have their email addresses, the alternative manner of service can be, these are the manners of service that can be used by the court so that at least service can be effected. So the regulations do not come up with anything more than that, except to provide for the steps that needs to be taken in order to ensure that service that ultimately does occur. So now, if they disappear, then they can be served by WhatsApp, for instance, once the court has authorized the manner of service. Because you remember, what I've mentioned is that the court has now various options that are available before them to ensure that the service gets effected. This is one of those measures. We know that people do run away, they do disappear because they know that something is coming their way. So now I think with these measures of the alternative manner of service in the form of substituted service will go a long way in trying to prevent the dodging of service of documents by the respondent. So if service has been effected by way of Facebook, if I may take that extreme example, if the court has authorized that and then service is effected that way, you remember I did mention that you must take, there must be a screen, a screenshot as an indication of the service on the respondent. So if it is served that way and the conditions contained in the protection order are breached, then the respondent will be liable in the same way as the respondent will be liable for the breach of the physical domestic violence protection order, the breach thereof, that is. Thank you.
Yes, thank you, Mr. Nyongwane. And I think we're also most aware of how these perpetrators try and dodge, and that's why we also propose the amendment to Section 3 of the Act, where you'll see that the arrest of the respondent no longer has to be at the scene of the incident of the crime, but he has to, it says there that that a person who attends the scene of an incident of domestic violence may arrest the person, and that the person doesn't have to be at the scene anymore. So if the person is ducked around and hidden in the house next door, for example, the police are still able to arrest as well. As you're well aware, they've come up with very creative ways of trying to dodge the long arm of the law. Having said that, I wonder if anyone else has anything to add or a burning question, because we are now 3 minutes away from the end of our meeting, and I do want to respect your time as well. And I do apologize at this point for the dodgy start that we had due to the technical glitches. Are there any other burning questions from anyone? Well, I think that then brings us to the end of the session, and all that it leaves me is to say thank you so much for, there is a question that comes in at the last minute. So is that Mr. Niklasen? Would you like to come in, please?
Good afternoon. Thank you for I'll be very brief. Thank you for all the panelists and everyone attending. We're getting somewhere. I just have a short question. I wanted to check with regards to the manpower of the resources of our law enforcement who will be involved in executing, obviously, the service. Obviously, I'm quite aware of electronic service, blah, blah, blah. But with regards to at times, you need to obviously ensure that there are proper enforcement as well of the proceedings, and bringing the perpetrators to court at times by breaching the protection orders or violating, if I might put it that way. Do we have enough resources in this regard? Thank you so much.
Thank you so much for that question. I think if I may also just have a stab at that answer. If we're looking at manpower, and the whole idea was to not only have the burden on the police as it currently is, and to have a clearer pathway of services. So you'd also have people going through the social services and being referred through that route as well to the courts. But having said that, I'll just hand it over to Mac if you want to add to that. Thank you.
Yes, thank you. That is a very important question to raise, except that we, as justice, we cannot give or do justice to responding to that question, because the police are in a better position to be able to say to us, they are going to do this and this in order to ensure that they've got enough personnel, they've got enough facilities to make sure that they can accommodate a huge number of documents coming their way from the clerks of the court. They have enough personnel to be able to be assigned to go and serve the monitoring notice and etc. etc. We are hoping that the police are working to ensure that there will be enough personnel to be able to undertake those tasks. Unfortunately, I cannot take this response further than that because the police will be in a better position to be able to respond to that. With all that, I am giving back to you, moderator. Thank you.
Thank you, Mr. Makulubete. And I think one of the things that we need to say as well is that one of the reasons why the legislation has not been operationalized yet is to get things in place and to have pilots run. And we do hope, as you know, that things would run smoothly. We would hope that there is sufficient processes and time in place for training. And I think that is, as I say, the reason for this piece of legislation only coming into operation a number of months after the other two pieces of legislation have already I hope that sufficiently answers your question, although it doesn't give you an exact answer. And I don't want to put the police that are on this platform, on the spot for that. Thank you. Is there any other question? Right, so then if we've come to the end of our webinar, I just once again want to say thank you to everyone. Thank you for your time, for being so gracious in accommodating us with the technicalities at the beginning. I want to say thank you also to Mr. Mkhulubeti, not only for your webinar, but for the exceptional amount of time and effort that you've put into compiling these regulations and coordinating them. And I wish you all the best as you take it to the home straits. Thank you so much. Good afternoon, everyone. May you have a safe afternoon and go well. Thank you. Bye-bye.
Thank you very much. And thank you very much to everyone on the platform. Bye-bye.
Thank you. Goodbye.
Bye-bye.